London appellate lawyer Carolyn Brandow has the Lerners Appellate Group's top 5 appeals from the Ontario Court of Appeal for the month of April. Well, Carolyn, what is the first case on the list?
The first case is Stevens. This is a case involving the issue of the validity of a marriage contract. The interesting part of the decision in part deals with the ability of an appellant to ask for rectification of a contract at appeal when the appellant had actually opposed that same relief sought by the other side at trial. The Court of Appeal rejects that and provides some interesting commentary on rectification of a contract.
I understand the second case is Amyotrophic Lateral Sclerosis Society of Essex and Windsor.
In this decision, the Court of Appeal looked at a costs order made by Divisional Court to send the issue of costs of an appeal down to motions judge to be dealt with along with other substantive issues. The decision is of interest because it focuses, again, our attention on the fact that an appeal is a separate step, distinct and apart from other steps of litigation, and the costs should be dealt with by the panel that deals with the appeal. And the Court of Appeal also looks at whether the appellants were successful and disagrees with the Divisional Court panel on that issue.
And tell us about Amato and Welsh.
Amato and Welsh is an interesting decision on absolute privilege, and this is a principle that the Court of Appeal looks at in some detail to determine whether or not pleadings can be struck raising allegations of statements made by lawyers in a quasi-judicial proceeding. It's of interest because the allegations were allowed to go to trial and were not found to bar, or the privilege doctrine did not bar the claims going to trial, which may be a little bit surprising and may make some lawyers nervous that we have less immunity from claims than perhaps may have been considered otherwise. The privilege was noted to be focused in the roots of defamation law rather than protecting lawyers from immunity from former clients suing them, and that's of interest, and we'll see how that case develops as it goes back to the court system.
The Orfus Estate and the Samuel Bessie Orfus Family Foundation case is the fourth.
This case deals with summary judgment in the context of an estate litigation matter in which a testamentary disposition was an issue. This was two sisters fighting over the estate of their mother. The one sister had been estranged from mother for some time. The interesting part of the decision is that testamentary disposition cases or estate cases frequently focus on credibility, and that was raised by the appellant but rejected by the Court of Appeal as being truly the issue, and as a result summary judgment was found to have been an appropriate manner to dispose of the issues, and the Court of Appeal upheld the motions judge on that.
Rounding out the list is Goodwin and Olupona.
In this decision, the Court of Appeal looked at the charge to a jury as well as issues of findings of negligence against a hospital and a nurse in a cross-claim between a physician, hospital, and nurse, the plaintiffs having been let out of the action or settled with partway through the trial. It was a 32-day trial with a jury, and the jury's conclusions were given a lot of deference by the Court of Appeal, and there's some interesting commentary in the decision about the charge to the jury, what is necessary to be in it and what does not have to be repeated over and over by a trial judge in the charge to the jury, the trial judge being allowed to simply refer to other defendants as having the same principles of law to be applied by them by the jury, and complimented the jury for their hard work during the course of the trial in meeting their duty as jury members.
Well, thank you very much.
Thank you.